What constitutes the defense of entrapment? In this case, a paid undercover agent bought LSD from the defendant on 3 separate occasions. The defendant claimed that he was entrapped. If a defendant successfully proves entrapment, he is not guilty of the crime. The first deal occurred when the defendant asked the agent if the agent could help him out and buy some acid. The agent asked him how much he wanted for it, and the defendant responded with a price. The second deal occurred when the defendant told the agent he was going to buy some acid and wanted to know if the agent would like him to get some for the agent. The third deal occurred when the defendant asked the agent if the agent could help him out because he needed to sell some acid to make money. The agent bought drugs on each occasion. At trial, the defendant claimed he had no predisposition to commit the crime, he was not a drug dealer, and that it was the agent who made him sell the drugs. How would you decide this case? Was it the defendant's idea to sell drugs to the agent, or did the agent entrap the defendant into selling the drugs? We'll be back in a moment with the answer. Did the government entrap the defendant into selling drugs? No, said the South Dakota Supreme Court. A jury is to consider the origin of intent test to determine whether entrapment occurred. That test requires the jury to decide whether the defendant was predisposed to commit the crime or whether the criminal intent is traceable to the government agent. When the original intent to commit the crime came from the government agent who induced the defendant to commit the crime by persuasion, deceit, or inducement, then entrapment is established. But if the defendant was predisposed to commit the crime and was simply encouraged by the agent, no entrapment occurs. The court noted that there are 2 requirements to proving a defense of entrapment. 1, the defendant must show that the police induced the defendant to commit the crime, and 2, that prior to this inducement, the defendant was not predisposed to commit the criminal act. These requirements can be met by showing that the agent induced the defendant by appeals to friendship, sympathy, offers of excessive amounts of money, and appeals to the need for the drug. Additionally, a defendant must show that he was subjected to undue, prolonged, or persistent pressures that were exerted against him, that this inducement was dangled in front of him. There is no entrapment when an agent merely offers a defendant an opportunity to commit the offense. In this case, the defendant came up with the idea of selling drugs to the agent. The agent only obliged and bought the drugs. Therefore, no entrapment occurred. Remember, it's a matter of law.